Hello, Stewart and Stewart attorneys here. Darron Stewart, good to see you. We have with us Nick Wagner. Nick is in charge of our litigation department here at the firm. Very good lawyer. He's given us a few minutes to talk about a couple different things. And we love talking about client calls because we get client calls every day, and some of them are very interesting. And we get auto calls a lot. People are involved in auto crash. And one of the questions that often comes up in that conversation is, well, how long do I have? The wreck happened a month ago, 2 months ago, and how long do I have to bring my claim? And so we have to explain that process to them. So share with us a little bit about what are our time frames, what are some situations that might involve a governmental entity that might shorten those time frames and that process. How much time do we have?
Yep, so generally speaking, and that's a good question. It's probably one of the most prevalent ones that we get, but generally speaking, in Indiana, you've got 2 years to what I say sue or settle. Okay, for any personal injury case, whether that be a car wreck, where it be a slip and fall, trip and fall. Now, obviously, with any general rule, there's always exceptions. For example, in a situation maybe where you have a minor child who's been involved in a car accident with their parent as the driver. And so the mom or dad, if they're 18 or over, would have 2 years to settle or sue, as I say. And but the child, however, that 2 years doesn't start ticking until a certain point in time later when they turn 18 or reach what we call the age of majority.
So in that scenario, the child, regardless of how old they are, as long as they're not 18, they have until their 20th birthday.
Technically speaking, yes. But I don't want folks to take that the wrong way and think, well, then I'm just not going to do anything. You shouldn't wait.
Right.
We treat every case, whether it's a minor child or an adult, as one with that 2 year limitation period.
So if you have the two parents in the car and a minor child, you still want to file that lawsuit. If you haven't settled, file that lawsuit within that 2 years,
Absolutely.
Regardless of the child's age.
Absolutely. And you know, there's other, like I said, there's other exceptions too. There's a lot of pitfalls that can make the situation a lot more, I don't know if I want to say risky, but dangerous for you in the sense that you could miss a deadline and not be no longer entitled to compensation.
So what are some of those?
Yeah, so we get a lot of cases that involve uninsured and underinsured claims against people's own insurance company. So if John is out driving his car and he gets hit by somebody who has $25,000 in coverage, the state minimum, but his injuries are obviously more than that, worth more than that, then we need to see if we can access his own underinsured coverage through his own policy. Now, the 2 year rule does not apply to the claim against your own insurance company. That is governed by a different statute of limitations that deals with contracts and claims in contract. And you can have several additional years under the law to bring that claim.
That's a good point. Under a contract claim, you have 7 years, correct? And that is your insurance policy is really a contract.
Yep.
It's an agreement. If I pay this money in premiums, you agree to do these things if I have a wreck.
Now, what a lot of people don't know, even assuming they know what the limitations period is for a contract claim, there is nothing preventing the insurance company from reducing that limitations period in your contract.
You can contract that away.
Yep.
So, but what if there's a situation where I've got 7 years under my contract to file under my uninsured or underinsured coverage, but what about the insurance company coming back and saying, well, but if you don't file in that 2 years, you're giving up our rights to pursue that uninsured person.
Right. So that argument, that discussion, and really depends on the policy language itself, which is extremely important because what the insurance company is trying to do there is obviously minimize or eliminate what they have to pay you. Right. They want to make your claim go away. But generally speaking, and I've seen it happen before, but the Court of Appeals in Indiana has said that the insurance company has every right to contract away the general limitations period. So they can reduce down to 3 years in some instances that I've seen the time that you have to file a claim with your insurance company.
That can be very confusing. And it sounds like it boils down to it's 2 years. Sue or settle. That's really what you said at the very beginning. Get it done within 2 years and you cover yourself.
Right.
Except now there are some situations where it's not 2 years before certain things have to be done to protect your right to sue.
Right, right. So a lot of times we'll have folks come to us who have been hit by a municipal bus, or they've been involved in a wreck with a mail truck. Cases involving, and I'll leave the mail truck example to the side, that's a little different, but when it comes to a city bus or a city employee or a Department of Public Works vehicle or something like that, and this is just talking about car wrecks, you only have essentially 6 months or 180 days to file what's called a tort claim notice. And if you don't file that tort claim notice, then you are barred from recovery.
So what's the purpose of the tort claim notice?
Well, let's be honest. The tort claim notice is something that the legislature has set up to protect municipalities and to protect their employees from lawsuits, and it is a trap. It is a trap, and I would hate to know how many cases have come and gone because they've missed that 180 days because the folks just simply didn't know it was there.
Because essentially, if you don't file that tort claim notice within that 180 days, and not only file it, but file it correctly with the proper individuals, which could be a page long of people you have to notify. Yeah. If you don't do that within 180 days, the 2 years is out the door. It doesn't matter. You can't file a lawsuit. You can file it, but the court's going to dismiss it.
They're going to dismiss it. And I've been talking all about car wrecks with city bus. That same 180-day rule applies for if you trip and fall in a pothole on a city street. Mm-hmm. It's the same thing. If something happens at a city-owned building, at a jail, you've got counties involved. Any kind of species of a municipality, if they're involved, or a city, then you only have 180 days to do this tort claim, and you better do it right.
Yeah, the legislature's purpose, or what they've said the reason for the tort claim notice is, so it gives notice to those governmental entities that might be responsible for your injuries, gives them notice so that they can have that time for a proper investigation and preparing and looking into the case and see if it's something they want to resolve. Our experience has been that although investigation maybe it usually gets filed away somewhere, and typically what we see it used for is to deny your ability to file a claim if you didn't comply with the tort claim notice. Yeah. It's a real issue, and sometimes you don't even realize. I've had clients come that didn't realize the people that injured them were a governmental entity, because sometimes it's not so obvious.
Right.
There can be certain ambulance services that have city ownership. Certain fire departments, and we don't realize it. It's not so obvious all the time.
Well, yeah, and I don't know, at least in the last 10 or 11 years, I don't recall ever sending out a tort claim notice and then getting a response and them saying, "Yep, you're right, we're at fault."
How much do you want?
Let me get my checkbook out.
Right.
It's almost, unfortunately, it's a trap. It's a formality. But it's a rule that you got to play by, and if you don't, you're going to waive your right to any recovery.
Absolutely, absolutely. So to summarize it, we really got to live and die by that 2 year. Even though there are some scenarios where it could be longer than that, there's too many missteps that can happen, mistakes that can be made if you get outside that 2 years. In a typical slip and fall or automobile case, you want to file within that 2 years. There's also some things that reduce that time. The tort claim notice isn't filing a lawsuit. It's a notice to those entities that you have a claim. Here's what happened. It lets them know the basics of where it happened, who's involved, how it happened, the location, and so forth, so that they can do an investigation and let them know that you potentially are going to file a lawsuit, which you can then do. And then that sets up a situation where when you file a lawsuit, it won't get dismissed. Correct?
Right. Yeah. But these folks who are, if you're going through, you've got enough that you're dealing with in terms of your injuries and your medical treatment and your life and your job and your money that that should be the last thing you need to be worrying about on your case, which is why I always tell people, look, contact a lawyer, if for nothing else, to find out if you've got a case. Give Stewart & Stewart a call, and we'll walk you through the process.
One last thing I know you're always aware of in your litigation department, and you talk to your attorneys all the time about this, and that is filing lawsuit sometimes well within that 2 year period of time. If we don't, depending on the facts of the case, if we don't know for sure that we have all the correct defendants, the correct parties, and for example, if you have a slip and fall and snow and ice at a strip mall, and you know the strip mall owners and the business owners and so forth, but do you know the exact people that they may have contracted with to clean the snow off?
Right.
Maybe that. So if you file suit and they say, well, yeah, it's our property, but we have a contract that shifts all the responsibility for this incident to ABC Snow Removal Company,
Right.
and you haven't named them in the 2 years past, you don't have the right to defend it, and you're not going to be able to bring that case. And there's a rule with the procedures, civil rules of procedure, that says if you file that more than 6 months before the 2 years, so before the 18-month mark after and you say in there, hey, we've named all the proper parties here, correct? And they then have to tell you who other possible parties might be. We call non-parties. Yeah. They have to tell you before that 2 years runs. Right. So my point simply is you guys are all over that, making sure that our clients are protected. And there's a lot of different traps that we've talked about that you can fall into, and you got to be very careful about that. So we're always here to help you. Nick's team is ready to go and help you with any type of case you have. If you've been hurt in a car wreck, don't wait around. Give us a call. We'll help you with it. Thanks.